Everybody's ready. State versus Stevens, and you may begin, Ms. Nye.
Thank you. May it please the court, counsel. Probable cause to search a vehicle does not justify the search of a passenger of the car under the automobile exception. Because of the unique, significantly heightened protection provided against the search of one's person, independent probable cause particularized to the passenger must be established to support the warrantless search of an occupant of the car. In this case, because the police did not have probable cause to believe that evidence of a crime would be found on Yale Stevens' person, after a drug dog alerted on the empty car he'd been riding in, the district court erred in denying his motion to suppress. As in all probable cause determinations, the facts are incredibly important. In this case, Yale Stevens was a passenger in the car that his brother was driving, his brother Kyle. Trying not to get those names confused. Yale sat in the rear passenger seat. The car was noticed by an undercover detective as it was driving in the vicinity of a suspected drug house. But the car was ultimately stopped by a different officer for having a brake light malfunction. Once the car was stopped, a canine unit was called in. Both Kyle and Yale turned over their identification. Ultimately, Kyle, the driver, was arrested for failing to have a valid driver's license. The drug dog, and so he was removed from the car and arrested. Yale was asked to leave the car as well and stand on the sidewalk while the canine sniff was, yeah.
Let me get to what is the heart of the case, because I view this as a pretty close case. According to the testimony, I'm not a dog person. But according to the testimony, this was a dog who alerted by sitting. It was alerted passively. It was, you know, this dog from Slovakia trained in the North Carolina Tar Heel Canine. Watching the video, the dog is moving constantly and jumping around. I don't see it sitting at all. I mean, am I missing something there?
Pretty quick. You know, I've watched the video many times. I think it's pretty quick sit. But I think your point sort of is well taken. I know at one point they ask Detective or Sergeant Clausen, who's got Yale on the sidewalk, and he says, you know, did you tell him the dog alerted or did you see the dog alert? And he said, I don't do that. I let the dog handler tell me what the dog did. And
it was a really quick sit. When I watched the video, it was a really quick sit by the driver's door. But the district court actually made a finding in his order that it not only signaled on the passenger side of the car when she was outside, and that's the part that I didn't see. Is that just a factual error that was made by the district court?
he is maybe misinterpreting what the testimony of Officer Simons, who says the dog was interested in the passenger side. You know, again, these things are quick. I don't see the dog is moving a lot, you know. I mean, there's, you know, I think, so you don't see a hit, and also the angle of the camera, you can't really see what's happening on the passenger side as clearly as what you can on the driver's side.
I think that from one of the officers, the handler, in fact, that he alerts by sitting and staring.
Wait, yeah.
Rummaging around, not being interested. I mean, but what do you make of, I mean, come on, it's 1 a.m, driving around in at least the vicinity of what is said to be a known drug house. Don't those facts tilt against you?
1 a.m, and I'm sorry, I don't remember what day of the week this was, if this was a weekday or not, I'm sorry. But it's 1 a.m. I think, first of all, this statement about I think in the minutes they call it a known drug house. When he testifies, he says it's a place I suspected. But there's no information to justify his conclusion that it was a drug house, that he thought it was a drug house. There's nothing, he doesn't explain his experience with it, other crimes, you know, that he's observed there. So I don't think that gets us very far. I think the district court as well thought that was too conclusory to put much weight on. And so they're driving around at night. I know it comes out later, they're musicians. There's people drive around late at night. So I don't think those get us very far to suspicion. And also even the statement, that the drug house, it's not clear they were seen leaving the drug house. It's not, I think this is also weird with the district court's ruling. In its initial statement of the facts, it says the two men were seen leaving the drug house. That's nowhere in the record. I don't know where that came from. And then obviously later in conclusions of law, the court says this was a conclusory statement that the car was seen leaving the drug house. I don't know if that means it was in the driveway and it backed out. Did he see the people go in? Was it just passing by on the street? There's just such a lack of information that you can't put much stock in that at all.
I'll call it a mumbling issue. And as I understand it, your client was directly asked about whether he had anything illegal, simple question, and generated a mumble of some kind. I mean, I'm not 100% sure I could give it verbatim. It wasn't exactly clear what he was saying, other than it wasn't a no, it was something else. Wouldn't somebody who is not engaged in illegal conduct just say no?
I think that's a fair, I think, interestingly, DeRay has a nice discussion on silence and how, and we've cited as well that there's a silence. We don't know what it was. It was mumbling. Maybe he was mumbling, no, I don't have anything. If he couldn't understand him, we don't know what he was mumbling. I think if you look at the minutes.
Evidence that he was also reaching for his pocket at the same time he was mumbling?
Clear, yeah. Well, I think the minutes, because you have the officer's testimony, he affirms what he said in his police report. And I think if you look at his report, it sounds like he's silent, tries to put his hands in his pockets, is told, get your hands out of your pocket. Then he says, I'm going to search you. Do you have anything illegal on you? And he reaches for a pocket again. At that point, the officer stops him, grabs his hand, pulls it out of his pocket. I would assert the search has started at that point, but because he's laid hands on him to stop him, and then the mumbling starts happening, and the officer then reaches into the pocket. So he says he starts to mumble something. It sounds like, the officer definitely thinks it's incriminating, thinks it's odd. What he's saying, that he's starting to say.
Stop him from reaching into the pocket, correct? In response to the question of whether or not he has drugs on him. So why wouldn't that fact alone be sufficient to support probable cause?
I just don't think that's enough. I think it's suspicious, it's curious. I just don't think that rises to the level of probable cause to believe he's got something.
Something has actually pulled it out, whether it be a weapon or drugs or whatever. At what point does it all of a sudden pass that?
Patted down once, and nothing by plain field, nothing incriminating was found. But at this point, the whole reason they're there is because the reason they're having this conversation is because the dog has alerted on the car. There's been no search of the car yet. There's another the driver was in the car as well. There's been no search yet of him, and I think that would be the sort of reasonable steps that should have been taken. They also could have had the dog alert.
The dog alert, you mentioned earlier that the handler said that the dog was interested on the passenger side, on the inside. There are cases that discuss the difference in a dog being interested and a dog alerting. Can you speak to that and what exactly the record is on what the handler says about what the dog did inside the car?
This is interesting. There are cases, and this is what I've, of course, learned a lot about dogs over the last, so there are cases that explain where there's testimony that explains the difference between a dog being interested or sort of maybe there's sometimes there's testimony that explains that there's steps that the dog is detecting something but not able to give a final signal, that there's sort of a lead up to a level of excitement shown in the dog usually that leads up to a final signal. But it's the final signal is, I've detected something, hears where I smell it coming from. The interest just shows that it's essentially, I guess, the dog is getting suspicious, I guess. But this case has none of that in the record. The officer has testified that this dog is all or nothing. She sits or she doesn't sit. It's real plain. He says, but then he says that she's interested because she spent the bulk of her time on the passenger side when she was.
Recall from the video, the dog runs out of the car and the handler forces the dog back in. Am I right? I mean, I don't know. Again, I'm not a dog handler, so I'm the wrong person to ask. But just a layperson's view, it is not remarkable to me.
The burden's on the state at this point. We have the officer, the handler testifying. There's nothing, actually I realized it doesn't even say, there's one place in the record where it actually says this dog is looking for narcotics. And that's in the suppression. The rest of the time, it's just a canine unit was called. They wanted me to conduct a canine sniff. We don't know what this dog was trained to detect, what sorts of drugs. There are bomb dogs. There are all sorts of different dogs that are trained in different things. Everybody assumes that the dog was alerting for narcotics, but we don't know what the dog was trained to alert. We don't know how sensitive she is, if she would react differently based on, the amount that she's smelling is, how long can drugs be out of the car and she'll still smell them. There's just nothing. And
At any point show the officer putting a hand on the rear quarters of the dog to influence it to sit?
I do not recall that. Yeah, I don't recall that. So, I guess skipping past the facts, the second issue, yes.
I'd like you to address what I would characterize as the other circumstances issue here.
But sort of the factors that are sort of generally taken into consideration under Brubaker, the physical appearance. We're stuck. We have the record. Mr. Stevens thought what he had was meth. I think he thought he bought it, but there's no evidence that he was under the influence, that he'd actually ingested anything and was demonstrating intoxication or being high on meth. The packages were still sealed. They look like meth, but again, this is street drugs, and people get ripped off all the time. In fact, we have a crime that is selling a fake drug, right?
As Brubaker, I don't think. In Brubaker, we were dealing with pills, and the testimony was, well, the pill is kind of consistent with, and which is kind of weak. And but here, if I understand it correctly, you've got a baggie and it's got a crystalline substance, and so it wasn't. I think the field test is very problematic. I get that, but this wasn't nearly as ambiguous as in Brubaker. In Brubaker, it could have been aspirin, I think, was part of the argument. But here, the appearance pushes you down the line further than in Brubaker, and then you have your own client say, well, we paid $30 for it.
I think definitely he believed that that's what his statements, he believed that's what he had, that's what he was intending to buy. But I'm not as convinced by the appearance, given that it was a street drug. I think that's less compelling than one, case where you have a prescription medication that's uniformly produced by a manufacturer, and they all look the same, and they're stamped in shapes and colors. Yeah.
Test challenged, though, in the district court?
No, this was on the minutes, so the field test gets in. The field test wasn't actually submitted. It was just statements about the field test, but yeah. So I think it's part of the record, but we know what we know about field tests. So I think the weight you can give it, how reliable it is, goes into the consideration of whether the evidence is sufficient.
Set aside this mumbling or non-responsive response to the question, because we shouldn't consider silence as supporting probable cause, right?
I think the silence is not an appropriate consideration. I think there's two reasons. I think it's fair as well with mumbling, since we don't know exactly what he said, mumbling is very similar to silence. And we don't know why, was he really mumbling? Was there another reason the officer couldn't understand him? So I think mumbling is you don't know what that means. But as well, I still assert that by the time he's mumbling, according to the minutes, the officer's already removed his hand and started the search, so it's not appropriate. And I'll be back on rebuttal. Thank you. May it please the court.
Counsel. I'll first start with some of the facts relating to the canine that are shown in the video. We believe the video exhibit shows that the canine Aura began walking around the vehicle at the 9-minute, 37-second mark in the video. She goes all the way around. She gets in and out of the car twice. And the last time she sits down outside the driver's door after reportedly spending the majority of her time on the passenger side. And Officer Simons, the handler, said he was very concerned that she spent most of her time on that and believed.
This is what the officer said at the suppression hearing. It's very obvious, talking about when the dog alerts. The dog's tail stops wagging. The dog sits and stares at where the odor is coming from. Do you see the dog's tail ever stop wagging on that video?
Well, the Officer Simons also testified that when the dog's in the back seat of a car or the front seat, it's very hard for the dog to sit. But the only thing shown on the video is from the dash camera parked behind, and it's dark. So you just see the dog going back and forth in the car, getting in and out, and the total time was just 1.5 minutes.
So I think we need to keep separate kind of what the dog did outside the car and inside the car. And the district court expressly found that she signaled on the passenger side of the car when she was outside. And I don't see that in the video, and I don't see that in the handler's testimony. So do you agree that that was a factual error by the district court? And what do we do with that when the district court thought this was already a close call, if he also made that factual error?
I agree that was a factual error because I saw in the video the dog sitting down outside the driver's door after getting in and out of the car and looking around twice. I would point the court to a very recent Court of Appeals decision that will be published, State versus Carson, where that court found probable cause despite the fact that the canine had not given the final response signal, had just given other alert behaviors. And they used what they called a practical common sense standard.
Difference between alerting and being interested? Because the handler talked about the dog being interested on the inside, but as I understand it, there's an interest, there's an alert, and there's an indication, and those are all three different along the spectrum.
Yes, those are different, but I think the circumstances are relevant. If a dog's in the back seat, it's a German Shepherd, does it have room to sit down? The handler was observing the search and said that she spent the majority of her time on that side.
Whether the dog alerted or not. I mean, what are the facts? Assume the dog did alert to the driver's side of the vehicle. What facts would then extend probable cause to the passenger in the back seat of the vehicle?
I think that the discussion in the Carson case, and there's also an Eighth Circuit case and a case out of another state that talk about the dog doesn't give the final signal, but there's enough it's enough of a behavior that's recognized to show that the dog detected a.
It seems like the critical fact is there's sufficient evidence to show that the occupants of the vehicle are in some sort of common enterprise. So, for example, drugs are open and obvious in the cab of the vehicle. it's reasonable to assume that everybody in the vehicle knows about it. Probable cause extends to all of them. Here, you have an alert on the driver's side door. How does that indicate or evidence some sort of common enterprise between the two people in the vehicle where it'd be reasonable to conclude the passenger was also engaged in drug activity?
The fact that the dog spent the majority of her time in the passenger side is a relevant factor to consider. The dog sitting outside the driver's door, she wasn't doing that in the front seat, so we don't really know. It's kind of ambiguous whether the sit outside the car was for the car as a whole, a specific part of the car. We don't know that.
Could the dog have been brought to him, to Yale Stevens, and sniffed him?
That's what the defense suggests, but I would say that I don't think that is allowed under current state of, how the dogs are trained.
Not because there wasn't probable cause, or based upon a limitation in training?
Trained to find controlled substances in places, and we don't really know what behaviors they would exhibit if they went up to touch a passenger.
How about the drug house issue? It seems to me, and I want you to correct me if I'm wrong, but there's not much in the record related to the drug house other than it's a suspected drug house. I mean, the label appears. If that appeared in a search warrant, if an officer said in a search warrant, the application that it was a suspected drug house without any other detail about, we've been observing it, there's traffic coming in and out at all odd hours, and we have an informant that tells us this, that, and the other thing. But the mere statement of suspected drug house, I think even the district court characterized it as weak. Isn't that fair? I mean, don't you ordinarily, in showing a probable cause, if you're going to use the vicinity of the drug house, you got to have a little more than just the label?
For a search warrant, you would. The minutes in this case provide that the car was seen leaving at 12:45 a.m. A known or suspected drug house, both descriptions are in the minutes, and in an area of high drug trafficking. That is why he called for the canine unit to come to the scene.
Seems a lot weaker than for example, our Hillary case, where the observation later held to support the stop was that he had gone up to the door of a known drug house where there had been an overdose death recently, and then had a brief interaction and walked away. I mean, that seems like that's okay, but you don't have much seen leaving. It's so vague.
As I said, I think you would have to have more to support a search warrant to search a particular home or other property. But
Based on what Justice Apple was asking, opposing counsel a little bit ago, regarding the evidence that was actually confiscated, I've seen the paperwork that talks about 2 different items being held for investigative purposes. Typically, I would see, and it might be part of the record, I just can't get my fingers on it, I would see some sort of a transfer to the DCI lab for it to be conducted. I'm just curious, do we not have any kind of a report beyond the field test because it was pled to on the record, on the minutes? Was it in the process, the testing? Did the defense cut that short? I'm just trying to figure out why we only have field testing.
do have statements about how the evidence was taken into police custody and
Getting it verified.
the lab. So why they seem to have a number of months, why the lab report didn't make it back. But
Lab, and there's nothing in the record on what the results were?
the field test results. We believe that
Had situations of positive tests, for example, in the juvenile arena when a parent tests positive on an instant test for meth. that can't be grounds to remove the child. It needs to be confirmed. Should we be thinking something like that on these lines as well? Is a field test trustworthy enough? I'm just trying to, or did the defense jump the gun and say, I want to hurry up and plead before there is a confirmation?
I believe defense waived error by stipulating to trial on the minutes. Therefore, waiving that challenge. The unpublished Court of Appeals decision of State versus Pettijohn talks about that on appeal, the defendant challenges the reliability of field test results, but the defendant had stipulated to trial on the minutes, which relieves the state of laying the foundation for admission of the field test.
Comes in, but the question then is, what value does it have? And the answer might be 0.
Alternatively argues that there is ample circumstantial evidence, as approved of in State versus Brubaker, that we have the leaving the drug house, early morning hours, the canine's behaviors and responses. When the defendant is asked, do you have anything illegal on you? And he reaches for his pockets and says, it's in there. The defendant then later uses the word dope. His brother says it's meth and he's a longtime addict. It's a crystalline substance in a heat-sealed bag. Stevens said they paid $30 for it. Both bags were small user portions. And we believe that's sufficient to confirm the substance.
Sure. As I said before, the evidence of the, with respect to drug was weaker in Brubaker maybe than here. But in Brubaker, interestingly enough, the drugs were found with a glass pipe and what seemed to be paraphernalia, and that still, the proximity wasn't enough. I guess the question is, when do circumstances ripen enough to sustain your burden on the positive identification, I guess?
What you had was a pill of a certain appearance, and because that could look very similar to.
If there's a big, thick documents you can kind of look through, and, it could have been a lot of things, as it turned out. But interestingly enough, Brubaker, the proximity of the pills next to a glass pipe is a lot stronger than the proximity to the so-called drug house here, I think. And still, it didn't carry the day in Brubaker.
We believe it's sufficient in this case.
Finish up, I want to ask you, what is, going back to the drug search itself, or the canine search, what is the basis for the warrantless search of the person? I think that it seems like that the parties seem to stipulate that this is a exigent circumstances automobile exception to the warrant. But do our cases really use that to allow officers to search a person? Or do they talk more in the context of probable cause to arrest, which kind of goes to the idea of why this needs to be particular to the defendant?
That brings up a point that the state wanted to raise, is that if you have probable cause to support an arrest and a search incident to arrest, why should the same probable cause be insufficient to search without making an arrest, which would be a lesser intrusion?
Specific identifiable evidence of probable cause to arrest Mr. Stevens in this case?
The canine alert, and then the officer's conversation with the defendant about, do you know why the dog would alert inside the car? No, I don't know. Do you have anything illegal on you? No response. Well, I'm going to search you.
He could have.
Let me ask. So, you can't, just because the officer says, do you have anything illegal, and then the person doesn't respond, you can't say that that's a fact that helps demonstrate probable cause, because then that will automatically be added to the mix in every single case, because the officers always ask that. And what's the person supposed to do? They either deny it or say they have something illegal, which is what the officer hopes for, and that would be significant, and that would demonstrate probable cause. Or they could stay silent, which is their right. You can't draw an inference from that, can you?
Was focusing on the fact that he asked him again, and his hands moved towards his pockets twice. And the second time was when he asked him again. So do you have anything illegal on you?
Right before they even looked in his pocket, could they have arrested him without looking in his pocket?
We believe so. When we believe the minutes of testimony reflect that what Officer Clausen heard him say as he was reaching for his pocket the second time was, "It's in there."
He didn't know what he said, but I thought Clausen's testimony was he did not say that he had something in his pocket.
He said he mumbled what he thought he heard was, "It's in there," and that's in the minutes. I realize the district court didn't take that as being.
At the point at which he's already, I can see I'm getting added to the list here. Isn't that at the point where the officer is already commencing the search?
He said he's going.
At that point, I mean, you would say the officer is really.
At that time. The state would respectfully request the court affirm the defendant's conviction on all grounds. Thank you.
Aye.
Thank you. I just wanted to sort of address some of the things that came up. Officer Simon's report is very short. His testimony is very short, but he does say that he, in preparation for his testimony, he rewatched the video, and his testimony is, because I found the minutes are not, it's not super clear when, because he doesn't even talk about putting the dog inside the car in the minutes. But on page 23 of the suppression hearing, he said, you know, at the beginning he says, I rewatched the video, and then he explains that the dog alerts on the driver's side door, and then he says, and then then what I do sometimes is put the dog inside the car to see what happens. So that's on page 23, that the dog alerted before it was on the driver's door. And I think there's a quick sit there. I don't recall that he helped the dog do that, but I would definitely look for that. Also, again, there's no testimony. I've seen in some other cases, there's testimony that maybe there's reasons that certain dogs, you wouldn't let them sniff a person. And I'm assuming that these are probably more of the aggressive alerting dogs rather than a passive dog. But there's nothing in this record. And Tedford versus State, Florida case talks about that they did do, you know, because that defendant challenged the sniff of the dog or of his person, and the court concluded a free air sniff is fine in a public location.
The evidence. Did the defense cut short the state's opportunity to have a confirmation by pleading beforehand, or the record mentions, I can't remember which, it was in the court's order. It says that a field tested positive as methamphetamine, looked like methamphetamine, substance was sent to the lab for further analysis, results not included in evidence, via the stipulation between the parties. And I'm trying to find any real stipulation. I think there isn't anything in writing or referred to during the hearing.
When you say stipulation, I assumed he just meant the stipulation to the bench trial, right? That they would, and that's on the record. Yeah, there's on the bench trial, in the bench trial record, they stipulate that the bench trial will be on the minutes and the video.
That regarding, for example, the lab results. Can you tell me the time frame? When was the field test evidence or the substance sent to the lab compared to when was the plea entered?
You know, that's not clear at all. There's nothing in the record. What we have is in the minutes, in the summary, the minutes, not attached police reports. In the minutes, it says they identify, and now I just forgot, I pulled out my minutes and they're buried in that pile over there. But they've identified the lab tech from the DCI lab in Ankeny and said that the substances were forwarded to the lab, and this person will testify about their tests and what this person found. But it doesn't actually say, it just says, and the attached reports.
Asked that the defense didn't want the confirmation back, hurry up and plea?
You know, this has taken months, I would assume. I mean, I'm sure I don't know what the, since nobody has the results, there's no indication that the defense knew any more than anybody else did what the confirmatory test would show. So there's no indication that the defense was intentionally trying to short-circuit anything, but certainly might have been in his best interest to
Could have waited, right? They could have challenged it, and they never did, right? Challenge the field test, challenge what the pills actually were. And they just never did, right?
Obviously, the heart of their case was the suppression issue, and that's what they were the most concerned about, preserving that, and then agreed to the bench trial. So that, yeah, if he had gone to trial, he could have challenged even the admission of the field test, but he didn't do that. So I think it's proper to consider that the field tests, but I don't think you have to make the same assumption that they're 100% accurate.
Cause issue on whether there was probable cause to arrest. And I want to throw in a couple additional facts and tell me why that would not be enough. So take these as true, and I understand there's a little bit of dispute. One, you have the defendant leaving a drug house. It's late at night, 1:30 in the morning. He's with his brother. And from that, we can assume maybe that there's a common enterprise. They know what they're doing. They're not strangers to each other. I think that's a fair assumption. Two brothers in a car in the middle of the night. They're not strangers. They're probably acting in concert. And then the dog alerts to the vehicle, indicating that there are drugs in the vehicle. From that, why isn't that cluster of facts sufficient to establish probable cause with respect to both people in the vehicle?
Did the dog alert on the empty car, as in this case, or were they still so empty? I think, first of all, I'm not sure the common you can say they were both there, but I think without a little bit more that they were also dealing, so I don't think the common enterprise rises to the level like a Pringle common enterprise where
Two brothers in a car at 1:30 in the morning are likely to be acting together and in concert versus a passenger in an Uber. Okay.
But I think also the key difference is the dog alert on the car, on the empty car, means that there's some sort of drug somewhere in that car. The brothers are no longer in the car. We don't know what they're going to find in there. If they're going to find one little tiny piece sitting in the driver's seat, that, what we can learn from a drug dog alert is so limited compared to, what the officer might actually see. And so I don't think that gives rise to probable cause to arrest both of them, just the dog alerting to the car. I think there's too many unanswered questions still at that point. For the reasons argued here and in our brief, we'd ask for the court to vacate Mr. Stevens' conviction and remand. Thank you.
Versus Stevens is hereby submitted, and court is adjourned for the morning.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.